We're going to talk about the tragic accident that took the lives of a UGA staffer and a UGA football player following the celebration of Georgia football's second national championship in a row. And we're going to be talking about what the legal issues are in this case, where the case stands right now, and what potential claims that specifically the Willick family may have going forward. Ben, what's the biggest claim that is going to be facing anyone in this case?
Two people lost their lives in this accident. This was a horrible crash. If you've seen the photographs, this car was mangled. Two people died. Chandler Lecroy was the driver. She passed away. And in the rear passenger seat right behind the driver is Devin Willock, who was a football player, and that he also lost his life in this crash. The two other people, a UGA football player, Warren McClendon, and another UGA staffer, they suffered non-serious injuries. But Devin Willock has a wrongful death claim because this crash was not his fault. Chandler Lecroy was driving. There's no dispute about that. And so now that Devin Willock has passed away, his parents now have a wrongful death claim against Miss Lecroy and potentially the University of Georgia and potentially the bar that they left from. So let's dive into that a little bit. The value of a life in Georgia is the value of a wrongful death claim. It's a really open-ended, subjective value. It's basically defined as the value of that person's life to them at the time of the accident. And it takes into account their potential earnings over time. And we're talking about a very young person who would have lived a long time, who would have had a college degree, presumably, would have had potentially an NFL football career. So this is a huge claim that exists. The damages here could be in the tens of millions of dollars easily. So let's talk about who potentially would be on the hook for those damages if these are pursued.
So far, Devin Willock's family has stated that they're not pursuing a claim at this time, at least against the university. But how long do they have to bring the claim?
You have 2 years from the date of the accident in Georgia. In fact, in a wrongful death claim, it's the date of the death. So there's 2 years for them to bring a lawsuit if they choose to do so. So this case is still in the very early days. There's information, vital information that's just come out in the last few days. The AJC reported that Miss Lecroy's blood alcohol level was twice the legal limit, that apparently she was driving over 100 miles an hour at some point. There's evidence that she was apparently racing with another UGA football player, Jalen Carter, who's one of the potential top 5 picks in the NFL draft this year. It's a tragic, tragic thing that's happened, and it's potentially a very large liability here for some of the entities involved.
It's not automatic that UGA would be liable for this. There are several issues here. One, whether Ms. Lecroy was using that vehicle that was rented by the University of Georgia or leased by the University of Georgia, whether it was in use for employment purposes. And they've already made a statement, I think, trying to distance themselves from that potential liability claim, that there were several policies that were violated, that there was a strict policy against personal use. So they've made a statement that they're trying to distance themselves, but that's not an automatic defense either.
There's 3 basic entities that have liability here. All right, let's start with the most obvious one, which is Chandler Lecroy. She was the driver. She was negligent. The car crashed. She drove off the road. She was apparently speeding. The car at some point was at a high rate of speed. Now it's come back that her blood alcohol level was allegedly twice the legal limit. So there's obvious liability for this damage claim, this wrongful death claim for Chandler Lecroy as the driver. The fact that she was DUI also adds to the potential damages there. So let's just take it as an assumption that Devin Willock's claim is in the tens of millions of dollars. Now, that doesn't mean that the family would be able to recover from Chandler Lecroy millions of dollars if she doesn't have millions of dollars on an insurance policy. This is a young person, presumably with few assets. So the question is going to be, how much insurance was she carrying at the time of the crash? The minimum limits in Georgia are only $25,000, right? So I think that it's quite possible that even though his claims are tens of millions of dollars, potentially, there's only going to be a small amount of insurance on the driver's policy. Therefore, there's other possible avenues where the family could find liability on other entities. And let's talk a little bit about those. What do you know about the bar where these people left from, Patrick?
Evidently, they were leaving from a place called Toppers, which is a gentleman's club, or better known as a strip club. And they were leaving early in the morning. And so The potential claim against them is what's referred to as a dram shop claim. And that's basically liability imposed upon an establishment that is providing alcohol to somebody that's noticeably intoxicated, that they willfully serve that alcohol to an intoxicated person who they believe or have reason to believe that this person may be driving a vehicle soon.
That's the hard part in a dram shop case, right? In a bar, obviously is serving alcohol. You leave a bar, you presume that they were serving alcohol to that person. So they have to be physically intoxicated to the person selling them the alcohol, but that's a hard thing to prove a lot of times. It's not automatic that Toppers is going to have liability here. It's possible that they may have gotten really intoxicated at somewhere else, went to Toppers for a short time, or were there and weren't really drinking a lot of alcohol. So the facts of this are going to have to come out.
There's a lot of discovery that has to be had to determine whether or not Toppers would be liable, which would require filing a lawsuit. And at this point, we don't have a lawsuit filed.
Right. They're going to have to look at how many drinks were served, who was serving them, did they seem visibly intoxicated, was there any indication they were driving? Again, there's sort of a presumption that people are going to be driving. But in Athens, there's people walking. It's downtown. Yep. You don't just drive up to the parking lot. You have taxi services and Ubers. So that's definitely going to be a viable defense for them that they didn't know that they were about to drive.
A lot of dram shop cases don't make it past summary judgment. I think the big question, obviously, is there's a potential liability with Toppers. However, there's, I think, a major liability issue with the University of Georgia, as well as a PR problem. It's hard to be a strip club and have a PR problem. Just your mere existence is a PR problem. But the University of Georgia is the flagship university. They have an extremely successful football program. This directly impacts that. And it's a highly respected educational institution in the state of Georgia. And so they have a reputation that they need to protect. They need to ensure that they are protecting their students and their staff and ensuring that these types of things don't happen. That comes into play in any potential claims that come forward, even if they have valid defenses.
Yeah, and there's definitely, it's never a slam dunk. Here's where the liability is for the University of Georgia. One, it was a vehicle that was not owned by the university, but it was leased by the university. So the university was in control of that vehicle and was providing it for its employees' use. Then there's going to be a question of, okay, was it being used for the purpose that it was intended for, which was allegedly from the university to drive recruits around? Well, these were football players already there. They were not recruits. This was at 2 o'clock in the morning. This was, according to the university, basically joyriding, that they were not doing any official UGA business at 2 o'clock in the morning when they left a strip club. That's going to be UGA's defense, right? They're going to say, we're not liable. And even though this isn't our employee, she was not acting as an employee at that time. She's not working in furtherance of the university. She was out for her own entertainment, right? But it's not always the case. There's some variables here, namely whether the insurance on that vehicle could apply even if there's no liability for UGA. There's a presumption when someone's in that vehicle that they have permission to drive that vehicle. So UGA had really strict policies for what that use is going to be, and they have to show they were enforcing it. That's the big question.
Yeah. That's the question. And if a lawsuit's filed, then like we said earlier, there's going to be a discovery process. So how do they deal with the use of vehicles that they're leasing and providing to employees throughout the organization, and especially within that department? But you're going to look at everything to potentially overcome their defense that this was a violation of their policies, which they've already basically stated to distance themselves from a potential liability claim.
Anybody who handles cases like this, when you're looking at employer liability, it's a fact-based question. There's just no way you can know this information without there being litigation, because you have to be able to interview witnesses, subpoena witnesses. There's numerous depositions that are taken to find out, okay, this was the policy. But if I talk to 15 employees who say that the policy was routinely not followed and UGA didn't do anything to correct those people or discipline those people, fire those people, then there is no policy, right? It's a policy.
Well, there's a potential that there's a known violation that they didn't even record the violation.
It's definitely going to be difficult for UGA to avoid any liability for this. It's possible. They definitely have defenses. It's not a slam dunk, but they're looking at potentially tens of millions of dollars in the value of Devin Willock's claim. And whether or not they are potentially going to be on the hook for at least some of that, I think is going to be a big question the insurance may apply even if there's no direct liability on UGA. It may apply to just whoever was using that vehicle with permission. If they're acting within the scope of that permission, then the presumption is it's going to apply. So I think that's one reason you're seeing so many, you're seeing statements from the UGA saying that this was absolutely beyond the scope of the permission. They did not have authority to use these vehicles for these types of purposes. We'll see if that's true. That was the policy on paper, they can probably prove, but we'll see if that was actually the policy in practice.
There's a chance that we don't ever see a claim. I mean, it's really up to Devin Willock's family to file a lawsuit to pursue this. Even if UGA has a valid defense, they very well could settle this so that they don't have to go through a potential major PR problem. They don't want to be the university that provided this vehicle to one of their staffers who was driving around intoxicated with, two of their students and athletes, and that they ended up dying. The litigation for that would be very public.
Yeah, that's what I was about to say. All of these things we're talking about, if litigation was pursued, all of these depositions and the discovery is public in Georgia. Unless it's under seal, it's usually not. So UGA will look at that very closely to determine if things are going to look badly for them or it's going to be trending towards Mr. Willock's claim being valid against them. Then it's probably something that you're going to see the UGA deal with some type of monetary settlement. Definitely a real danger here for the university. Even if claims are ultimately successfully defended, you're talking about years of litigation and a potential PR problem. And I know that they're not concerned just about the PR here. I mean, a student has died and a staffer has died. And it definitely is a very tragic day for UGA on a day that was supposed to be for a huge celebration. I mean, something unprecedented, back-to-back national championships. And unfortunately, we're talking about this 2 months later. Something much greater was lost that day that could ever be achieved, on an athletic field.
That it's something that we're going to follow the case if it's pursued. And we'll keep you posted if there's anything that's filed in this case on behalf of the Willick family primarily. The other two individuals have claims, but they're obviously not as large because the other two passengers were injured. And my understanding is they're not catastrophic injuries.
Yeah, and just to explain to people, each person's going to have different value of damages. And if you have a sprained wrist or whatever, it's the medical bills and your pain and suffering for that. When you have a death, the damages are the value of the life of the decedent. And that is completely subjective, completely open to what a jury would award to that. What is some jury going to say his value of his life was if they had to put a dollar amount on it? And those numbers can be tens of millions of dollars. It's in Georgia, we've seen wrongful death claims upwards of $100 million. And you're talking about a young person with a long life ahead of them with a college degree. And you also take into account the economic loss. That's just one factor. I'm sure this isn't the last that we've heard of this case, and we'll be watching it.
All right. We're going to continue to follow this story. Subscribe so that you get notifications of our future videos.